questions. Now, is it the misdemeanor that's being sealed, or is it just a violation that's being sealed?
It's the misdemeanor. A
The
violation.
misdemeanor?
It's the Class B misdemeanor that's being sealed.
Okay. And the sealing can't be waived at all, correct?
It could be. I mean, the courts can decide to waive it.
No?
It can't be waived, but if it can be opened, if the courts decide that it needs to be opened.
Well, so if I have criminal sale of a controlled substance, right, and it's an amount that's a felony, right, because you're saying a misdemeanor, and I want a plea bargain to bring it down from a felony to a misdemeanor, right? But part of the deal is to waive the sealing.
Well,
We
Mr.
can't
Graf,
do that here, right?
No, those are not the violators that we're talking about at all.
Well,
We're talking about people who had a small amount that is quite honestly just a violation, and they were asked to take it out of their pocket, and
Well-
so now it becomes a misdemeanor. Those are the folks that we're talking about.
well, it's a guy smoking a joint on the street too, right? It's a person smoking a joint on the street. Correct?
It could be.
Okay.
That doesn't mean that they are selling drugs. That means they were smoking one.
Okay. Yeah, well, that's the charge. But if they're found to be selling it, okay, I'm a prosecutor. I have a person arrested for criminal sale of marijuana, okay, and I want a plea bargain.
Right. Well, one of the things that this legislation does do, Mr. Graf, it does allow the courts, the DA, an opportunity to offer a different plea.
Well, let me finish the question. If you have a plea bargain and they plea bargain it down, this is what they're convicted of. So if they plead guilty to the misdemeanor, all right, then it's automatically sealed, correct?
Just to be clear, the DA can make a motion for it not to be sealed.
Well, I think in the bill, what happens here is if they've had a conviction prior, right, and they make a motion to seal that record, that prior conviction, not going here forward, they want to seal that prior conviction, right, then the DA gets an opportunity to put in a motion for that prior conviction to stop the sealing, correct?
It's at the time of conviction that the DA can make that motion.
Yeah, but in this bill, can't I go back before that? So if they
Yes.
were convicted prior,
Yes.
and in order for me to go back, I have to make, it's not automatically sealed if it was a prior crime. I have to put in a motion to seal,
Right.
okay? And when I put it, and then the DA can respond. But in
Right.
this case, the DA can't respond because now going forward, if it's a conviction for this, it's an automatic sealing of the record.
The DA can always respond.
Okay, but in your legislation, right, it says the sealing is automatic, that they can't waive the sealing.
Sir,
So,
it does say that. But
Okay.
I'm telling you that the DA can make a motion on this issue.
where does it say that in the bill, please?
It is already an existing law. 16050, section 16050.
Where
of
is
the
it in the
existing
bill?
law. So there's really nothing in this bill that changes existing law that gives the DA the court's privilege.
Okay. Right. If we
Just the
look,
DA, rather, not the
yeah,
courts. I'm
if
sorry.
we look at first page, you go to line K,
First
keep
page.
going down, and now you have the new line part. So if you go to page 2, line 1, the penal law provided, however, that the record of such conviction does not demonstrate a conviction under subdivision 2, no defendant shall be required or permitted to waive eligibility for sealing pursuant to this paragraph. So what that's saying is, if I'm a district attorney, I'm looking at reducing the charges for you. However, I want you to waive the sealing. And what what that would do is you would have the original charge, and it would show that you pled to a lesser charge, and it would stay on the record. Okay? And that would be part of my plea negotiation as a prosecutor. Under this bill, and I think it even says it further on, if you read it, that it would be void. That it would be void if the DA tried to do something like that. Notwithstanding. Isn't that correct?
Okay. So, Mr. Graf, I'll repeat again. The DA can motion under existing law. And we quoted the number already,
All right, let's try it.
16050.50.
All right, let's try it that way.
Okay.
So the DA can make a motion that it not be waived. I don't think I agree with you here because that's not what it says.
That not that it not be
But if
waived,
I'm
that
gonna
it not be sealed. The
All right,
DA
but-
can make that recommendation.
All right, but if the DA doesn't make a motion, it's automatically sealed. Right?
Yes.
And then it's up to the judge to approve that or not, correct?
The judge can approve it, and or the Department of Criminal Justice.
Okay, so now if I turn around and say I'm the prosecutor, I'm reducing the charges, and I'm saying, look, I'll reduce your charges, but it's got to be that the sealing is waived, right? I can't offer you that. That's up to the judge. Because I have to put in a motion to see if the judge will do that.
Okay, so I'm being advised by counsel over here that this is not asking to change existing law. So if you want to get a plea, then you have to look at using some law that's already in place. You cannot use this law that we're proposing here today.
Yeah, I've read, all due respect, I've read.
Subdivision 1 is not sealed.
Yeah, I read through the entire bill. Let me try this another way. All right? Now, if a person has marijuana in the open, okay, and part of your reasoning here is that the people are getting arrested for having marijuana in the open or burning marijuana, right? They're still going to get arrested, right? This bill's not going to prevent them from being arrested for that.
No.
And they're still going to be charged with a misdemeanor, correct?
Yes.
Okay. And how many bites at the apple did they get here?
Okay. They get one. The first one can be sealed. The second one cannot.
Yeah.
Within the charge. Well, he's a prosecutor. He understands that. The
Right.
first one can be sealed. The second one cannot.
Well, the thing is, though, according to this bill, if the records are sealed, and they're saying the court is sealing it in a way so that if you get locked up again for it, I can't see the first one because it's like you've never been arrested.
Well,
That's not what that says. Read the bill.
okay, the records will not get sealed if the district attorney makes a motion.
Ms. Walker, why do you
that the
rise?
record remain unsealed, or the court on its own determination finds that the interests of justice require it to remain unsealed.
Ms. Walker, why do you rise?
Will Mr. Graf yield for one question?
Sure.
Mr. Graf will yield.
So, Mr. Graf, it seems like you want some explanation of the present law. Is that correct?
Excuse me?
Would you like to have an explanation of the present law around sealing or unsealing a record?
No, I want an explanation of what this bill is doing, because this bill is changing the sealing. Because right now it's not sealed, all right? This one automatically seals it, right? And what happens here is it even says it, you know, I can find it. It even says that the purpose of this is so that you cannot consider this, right, if the person gets arrested again for the same thing.
Can I
So it will-
submit one quick
Well,
thing?
let me finish.
Okay.
It won't show that the person was arrested for this. So the court won't know, or the DA won't know, that the person was arrested for this. Sort of like if you have a DWI, first offense, second offense is a felony, right? But if the record's sealed with the DA and they don't have, and they're not allowed to look at it because what they're saying here is the chief administrator of the court shall develop and promulgate rules as may be necessary to ensure that no written or electronic report of criminal history record research
Right.
conducted by the Office of Court Administrator contains information related to the conviction for a violation.
Okay, I'm sorry, Mr.
So they're
Graf.
getting rid of any record of it. So now if the person gets arrested again, I can't turn around and see that to say he's going to be charged
I'm
with a
sorry,
second
Mr.
offense.
Graf. The reason why I made the request is because I wanted to clarify something for you. Presently, if a person is convicted, whether by plea or otherwise, that defendant can request the court to do an immediate sealing.
Okay.
It is up to the judge at that point to make a determination as to whether or not they will do so.
Yes, but under...
In many circumstances, some judge will say sealing after 60 days. Some will say, depending on the circumstances, we will do an immediate sealing. What I think this bill does is it provides an opt-out mechanism as opposed to an opt-in mechanism where the district attorney will have to request that there is no immediate sealing of a person's conviction record.
According to this bill, there's an automatic seal,
Exactly.
and that the
So-
person cannot waive it.
No, the
Right.
person cannot waive his eligibility to request an immediate sealing. So no defendant, no district attorney can ask a person to say, I'm not eligible for something that's already given to them in law. But what I want to point out to you again is that this is only an opt-out provision as opposed to an opt-in provision because a defendant already has the right to make a motion to the court to request that his conviction be immediately sealed.
But that, you would agree that's very different than a person automatically having the record sealed, okay? Right? Then making that motion.
Well, I think now it just puts the onus on the district attorney to say, you know, we would prefer that this person's record stays open to the public.
Well, as
So-
a district attorney, I wouldn't be offering the plea bargains. So anyway, let's try this a different way.
Another question,
Excuse me?
Speaker.
Sure.
I want it to be clear that we're only talking about 25 grams or less of marijuana. We're not talking about a violent criminal. We're not talking about someone who has a consistent record of being arrested for marijuana or anything else. We're not talking about someone who's committed any robberies or raped or hurt anyone. We're talking about people, mostly young people, who have under 25 grams of marijuana.
Well, first offense.
And, Mr. Speaker, anybody can get access to these records under the Criminal Procedure Law 160.50. Under this law, for example, these sealed records shall be made available to a prosecutor when a defendant is charged in a later marijuana case or seeks adjournment of contemplation of dismissal. They can be released to law enforcement agencies upon a motion to the court showing that justice requires release of such records. They can be released to a licensing officer or an agency when a defendant applies for a gun license. They can be released to a parole officer supervising a person when a record was sealed while the person was under parole supervision. They can be released to a prospective employer when the person applies for a job as a police officer or a peace officer.
Can I ask a
And they
question
can be
on that?
released to a probation officer
Yes.
supervising that person when the record was sealed while the person was under some sort of probation.
So we don't want
Mr.
law,
Speaker,
we don't want law enforcement, we don't want, if I'm applying for a law enforcement job, we don't want law enforcement to know that they have this conviction.
I said the records can be released to the list that I just read.